Welcome everyone, and thank you for joining me today. We're about to explore the fascinating world of theories of private international law. On this first slide, I'll introduce the main theories we'll be discussing, including statute theory, international theory, territorial theory, local law theory, and justice theory. Throughout this presentation, we'll take a closer look at each of these perspectives and understand how they shape the way private international law operates. So, let's get started and delve into these important concepts together. Statute theory was introduced by Bartolus in the 13th century, and it's considered the oldest and most primitive of the theories in private international law. This theory was actually developed to address conflicts of law that arose between different city-states in Italy, as well as between Italy and other countries. To manage these conflicts, Bartolus classified statutes into two main types. The first is statuta personalia, which are personal statutes that govern individual status, like nationality or legal capacity. The second is statuta realia, or real statutes, which relate to property and tangible rights. Understanding these distinctions helps us see how early legal thinkers tried to create a framework for resolving legal conflicts across different jurisdictions. This foundational approach set the stage for the development of more sophisticated theories in private international law. Let's now explore the concept of statute theory, which is fundamental to understanding the application of laws. First, we have personal statutes, or statuta personalia. These are laws that specifically relate to individuals, such as the Hindu Marriage Act, Muslim Marriage Dissolution Act, or the Adoptions and Maintenance Act. Essentially, these statutes govern personal matters like marriage, divorce, adoption, and maintenance. One key point to remember is that personal statutes are applicable everywhere a person goes, no matter which territory they are in. Next, we have real statutes, or statuta realia. These relate to things rather than persons, with a particular focus on immovable property. Think land and buildings. Movable property, on the other hand, is governed by personal statutes. The critical aspect of real statutes is their territorial limitation. They only apply within the territory where the property is located. So, if a property is in India, Indian real statutes will govern it, regardless of the owner's nationality or residence. Understanding these distinctions helps us see how laws are applied differently based on whether they concern persons or property, and whether their application is territorial or personal. This forms a core part of the statute theory, which guides us in determining the applicable law in various legal scenarios. On this slide, we see how recognizing problems with classification led to the introduction of a third category, known as mixed statutes or statuta mixta. These are statutes that relate to acts like contracts and torts, and their application depends on whether they are signed or performed. To better understand whether a statute is real or personal, we need to look at its grammatical structure. If the persons involved are mentioned first, then it's considered a personal statute. For example, the Latin phrase primogenitus succedat in omnibus means, let the firstborn succeed in all things, indicating a focus on persons. Conversely, if things are mentioned first, then it's a real statute. An example would be bona dissidentium venient in primogenitus, meaning, let the goods of the decedents go to the firstborn, which emphasizes property or things. This distinction, whether persons or things are mentioned first, helps us categorize the statute correctly and understand its application. It's a key part of the statute theory, which aims to clarify how laws relate to either personal rights or real property. Recognizing this grammatical cue is essential for proper legal interpretation and applying statutes accurately. Let's now discuss some of the key drawbacks and criticisms related to the classification of statutes. First, there is the fundamental problem of classifying statutes itself. Even legal scholars like Cheshire have acknowledged this issue. For example, he questioned whether a law that regulates the capacity of a person to transfer property to his father should be considered a personal law or a real law. This highlights how complex and sometimes ambiguous these classifications can be. Next, we see that there is no scientific or consistent method for deciding which statutes fall into which category. There's no fixed rule or solid ground to determine whether a statute is personal or real. In fact, simply looking at the name of the statute, whether it comes first or not, is not a reliable way to classify it. Cheshire himself emphasized that we shouldn't judge based solely on the name, but should instead focus on the core substance of the law. Lastly, this classification approach is often incomplete and ambiguous. According to Savigny, the theory doesn't provide clear guidance on how to apply the laws in practice. This can lead to confusion, especially when a property is located in multiple jurisdictions. In such cases, different laws from different countries might apply to each property, which makes the process burdensome and inconvenient. Overall, these drawbacks highlight that the current methods of classifying statutes are far from perfect. They can lead to confusion and inconsistent application, which ultimately affects the clarity and efficiency of legal processes. Von Savigny was the founder of the international theory, which is also called the theory of natural seat of obligation. This theory emphasizes that, considering international comity, the application of laws should be as uniform as possible across different jurisdictions. Essentially, when resolving disputes between parties from different countries, we should look to apply customary and conventional laws that are most relevant to the specific case. To do this effectively, von Savigny devised a scientific method for deciding which country's laws should be applied. The core idea is to identify a legal system that is naturally connected to the facts of the case. This is what we call the natural seat. Now, determining the natural seat involves looking at several key factors. First, we consider the domicile of the person affected by the legal relation, that is, where they officially reside. Second, we look at the place where the object of the legal relation is situated, like property or assets. Third, we examine where the juridical act was actually performed, such as signing a contract. And finally, we consider where the tribunal or court that is handling the case is sitting. All these factors help us identify the most appropriate legal system to apply, ensuring that the law is connected to the facts in a natural, logical way. This approach promotes fairness and consistency in international legal disputes, aligning with the overall theme of harmonizing laws across borders. Let's move on to some of the criticisms of the idea of uniform laws. One major point is the false assumption that laws are the same everywhere. Savigny, for example, believed that customary laws of a nation should be applied universally. But what often gets overlooked is that these laws are not actually uniform across different countries. For instance, in the USA, gay marriages are legal and recognized, whereas in India, they are not. So, applying the same law without considering these differences can lead to issues. Another criticism is the failure to recognize the rich diversity of religious and ethnic groups. India, although a relatively small country, has a vast array of religions and ethnic communities, each with their own unique practices and traditions. Because of this diversity, India has struggled to create a single, uniform law that suits everyone. Now, when we think about the world as a whole, it's even larger and more diverse. So, the idea that one law can be applicable everywhere becomes even more impractical. These points highlight why the concept of uniform laws needs to be approached carefully, especially considering the complex social and cultural realities that vary so widely across different regions. This theory was developed by Ulrich Huber and A.V. Dicey, both from England. The main idea they propose is that courts do not actually apply foreign law directly. Instead, they consider the consequences that would follow if foreign law were applied. Essentially, what this means is that courts are always applying their own country's law, regardless of where the case is actually from. Now, focusing on Ulrich Huber's principles, the first point is that a state's laws have absolute authority only within its own territorial boundaries. That means laws are valid and enforceable only within the country's borders. Next, Huber states that anyone found within a country's territory, whether they are there temporarily or permanently, is considered a subject of that country and must obey its laws. However, Huber also introduces the concept of comity, which is a respect for foreign laws. He says that if a law has already been applied in its country of origin, other countries are generally willing to recognize it and give it force, as long as doing so doesn't harm the subjects of the country whose law is being recognized. This leads us to the territorial theory, also known as the theory of acquired rights. It emphasizes that the effect of foreign law is recognized only within the territory where it was originally valid, and courts will apply this law as if it were their own, but only within that specific territory. In summary, this theory highlights the importance of territorial boundaries and sovereignty when it comes to the application of law, and it underscores the idea that foreign laws are recognized mainly for their effects within their own jurisdiction. Let's look at some of the criticisms related to overemphasizing sovereignty in legal matters. First, when we focus too much on sovereignty, we tend to forget about international comity. That means we only apply the law of that specific state, based on its private international law, without recognizing or respecting foreign laws. Next, there's often a failure to identify the choice of law that the parties themselves prefer. Sometimes, parties want to be governed by a different legal system or forum, but this preference isn't always acknowledged or considered. This situation also creates practical difficulties and confusion. For example, it might lead to enforcing rights that aren't even recognized under foreign law, which complicates cross-border legal processes. Finally, it can create a vicious circle, especially when multiple parties from different countries are involved. In such cases, the question becomes, which law do we actually apply? This can lead to endless debates and uncertainty. All these points highlight how an overemphasis on sovereignty can hinder effective international legal cooperation and clarity. Let's talk about Walter Wheeler Cook, the founder of this theory. Courts traditionally apply their own rules, excluding foreign laws entirely. Cook aimed to improve this approach by introducing what we now call the territorial theory. He proposed that courts should always apply the law of their own land, regardless of where the case or the parties are from. However, there's an important nuance. If a foreign party is involved, the court should create rights based on their domestic law that are similar or analogous to the foreign law. In essence, courts don't enforce foreign rights directly. Instead, they enforce rights created by their own domestic law, but they consider the foreign law for guidance, especially when foreign parties are involved. Cook emphasized that even when a foreign party is involved, courts should treat them like a citizen of their own country. That means giving the same kind of decision as they would if both parties were domestic. This approach bridges the gap between respecting the sovereignty of each jurisdiction and ensuring fairness when foreign elements are part of a case. It's all about maintaining consistency and respecting the territorial sovereignty of each legal system, which is a key theme in our overall discussion of conflict of laws. Let's delve into some of the criticisms highlighted here. First, there's the issue of feudal intellectualism. Essentially, what you're doing at the end of the day is applying your own country's law. Trying to understand other countries' laws by looking at them directly can often be a pointless exercise. It's like forcing a square peg into a round hole. Each legal system is rooted in its own context, so applying foreign laws without considering that context can lead to misunderstandings. Next, we have the problem of ambiguity. The slide mentions that simply saying, "Consider foreign laws," leaves many questions unanswered. It doesn't clarify how to consider them, what the limits are, or which aspects should be focused on. This vagueness can cause confusion and inconsistency in application, which is problematic for a robust legal framework. Now, moving on to the emphasis on precedents. While precedent is important, over-relying on past decisions can be restrictive. Societies evolve, and laws need to adapt accordingly. Sometimes, previous rulings may no longer fit the current societal context, and there should be room to overrule or modify them to better serve present needs. Finally, there's the criticism that laws need to evolve over time. A decision made in 1800, for instance, might have been appropriate then, but it may be entirely irrelevant now. Laws are not static. They must reflect contemporary realities and values. Overall, these points remind us that legal interpretation isn't just about rigidly following past decisions or blindly applying foreign laws. It's about understanding the context, clarifying the limits, and ensuring our legal system evolves with society. Now, let's take a closer look at Dr. Graveson's theory of justice. At its core, This theory emphasizes the importance of delivering true justice by carefully considering legal precedents, good conscience, and equity. What this means is that applying the law correctly is absolutely crucial to ensuring that justice truly prevails. When we connect this to private international law, or PIL, we see that it aligns with three core promises. First, there's the sociological promise. This is about fairness on a broad, societal level. PIL commits to fair treatment for everyone, not just within national borders, but across the entire international community. So no matter where someone is from, they should receive just and equal treatment under the law. Next, we have the ethical promise. Here, the focus is on the role of judges. Judges bear a significant responsibility. They must administer justice with integrity. This involves rigorous training and a deep commitment to ethical practices, ensuring that their decisions are guided by morality, fairness, and impartiality in every case they handle. Finally, there's the legal promise. This one is rooted in the oath that judges take. It's a solemn commitment to uphold the principles of the legal system. When judges make decisions, they are bound by this vow, which ensures their rulings are rooted in the law and guided by justice. Essentially, upholding the law becomes synonymous with upholding justice, and that legal promise forms the backbone of the entire PIL framework. So, in summary, PIL's core promises, sociological, ethical, and legal, are all about ensuring that justice is delivered fairly, morally, and lawfully across borders. Thank you so much for being with me through this presentation. I really appreciate your time and attention. If you found this content valuable, I encourage you to subscribe to the channel so you won't miss any future updates or insights. You can also follow me on social media at Deep Law Lab for more discussions, resources, and the latest news. Once again, thank you for your support, and I look forward to connecting with you again soon.